Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we're here to provide clear and practical insights. Divorce is complex, but understanding your rights and options can make all the difference in the world. Now, while this isn't legal advice I'm giving you, it is designed to empower you with knowledge that you may need to move forward with confidence. Today, we're unpacking a critical question that's often asked. Can bankruptcy be used as a shield to avoid spousal support obligations? Well, the short answer is no. But the full story is certainly more nuanced. Understanding how spousal support interacts with bankruptcy law is essential if you're a professional, executive, or business owner who is navigating separation or divorce. Under Canada's Bankruptcy and Insolvency Act, spousal support obligations receive unique protections compared to other forms of debt. Section 178 creates a critical distinction. While most debts are wiped clean upon discharge from bankruptcy, spousal support obligations actually survive and remain fully enforceable. This means that if your former spouse declares bankruptcy, any court-ordered spousal support continues, and it continues unabated. The bankrupt spouse cannot escape their obligations through the bankruptcy process. They remain on the hook indefinitely. However, the treatment becomes more complex when we examine priority and timing. The Act establishes that the spousal support claims are provable in bankruptcy proceedings, meaning they can participate in the distribution of the bankrupt's assets. More importantly, these claims receive preferential treatment for amounts accrued in the year before bankruptcy, plus any lump sum amounts. Let's examine how Ontario courts have applied these principles through several key cases that illustrate both the protections and limitations that are involved. In the Mosera case, which scrutinized last-minute agreements, the court was vigilant against manipulation of the bankruptcy system. Mr. Mosera transferred $50,000 to his ex-wife just 10 days before declaring bankruptcy, claiming it was pursuant to a separation agreement that waived future spousal support. The court, however, found that this constituted an improper preference. Justice Cumming noted that courts must carefully examine separation agreements negotiated on the eve of bankruptcy that gives advantage to one spouse over arm's length creditors. This case demonstrates that timing does in fact matter. Last-minute financial arrangements designed to circumvent creditors will, in fact, face judicial scrutiny. In Ross v. Ross, this case illustrates how bankruptcy can constitute a material change in circumstances for varying spousal support orders. Here, the Supreme Court's guidance in Shriver v. Schreier proves crucial. The court emphasized that while equalization claims may be extinguished by bankruptcy, spousal support can potentially be used to mitigate resulting inequities, but this requires careful legal analysis and cannot simply disguise equalization payments. In Korn v. Korn, we encounter the critical distinction between spousal support and equalization payments. In this case, Mr. Korn's $3.6 million obligation was characterized as support payments in the agreement and court order, which proved decisive when he later declared bankruptcy. The court confirmed that amounts properly characterized as spousal support survive bankruptcy under Section 178, as I mentioned before, but cautioned against impermissible attempts to recharacterize equalization claims as support to gain preferential treatment. So, for potential payers, if you're concerned about future financial difficulties, understand that bankruptcy cannot eliminate spousal support obligations. This reality should inform your negotiation strategy during divorce proceedings. Consider the long-term enforceability of any support obligations that you do in fact agree to. Consider whether lump sum payments might be preferable to ongoing periodic support. Consider the potential for your spouse to secure charges or liens against your property. And for the potential recipient, if you're entitled to spousal support, the law provides significant protection, but timing and characterization does in fact matter, and the courts have held that repeatedly. Number one, for your purposes, ensure that proper legal characterization of payments as support rather than equalization. Two, consider seeking security for support obligations under Section 34 of the Family Law Act. Number three, understand the priority your claims will receive in any bankruptcy proceedings. A crucial point for high net worth individuals, equalization payments are treated very, very differently from spousal support in bankruptcy. The Thibodeau and Schreier cases make clear that equalization claims are released by bankruptcy discharge. They become ordinary unsecured debt that are in fact extinguished. The Supreme Court in Schreier noted that Parliament has specifically chosen not to give equalization claims the same protected status as spousal support. This distinction can have profound implications when substantial family property is involved. The Family Responsibility Office plays a crucial role in enforcement. Support orders can become liens against personal property, and these liens receive priority over most other creditors under the Creditors Relief Act. As demonstrated in Flewelling v. Flewelling, support orders maintain priority regardless of when an enforcement process is issued or served. However, the intersection with bankruptcy law is complex. While the Family Responsibility and Support Arrears Enforcement Act allows for powerful collection mechanism, Section 43 explicitly states that nothing affects rights under the Federal Bankruptcy and Insolvency Act. Courts remain vigilant against abuse of the bankruptcy system in the family law context. Warning signs that attract judicial scrutiny include, number one, separation agreements that are negotiated immediately before bankruptcy. Two, transfers of substantial assets to a spouse on the eve of insolvency. Three, attempts to recharacterize equalization payments as support. And four, strategic timing of bankruptcy declarations to avoid family law judgments. For high net worth individuals, several planning considerations do emerge, and you'll want to take note of this. Number one, timing matters. The 1 year look back period for preferred claims means recent support arrears receive priority treatment in bankruptcy. Number two, characterization is critical. How payments are characterized in agreements and court orders can in fact determine their treatment during the bankruptcy proceedings. Number three, security interest. Consider whether support obligations should be secured against specific assets, though courts require clear language to create true security interest. And number four, professional coordination. Make sure you ensure your family law counsel coordinates with insolvency experts when financial distress is in fact a possibility. The intersection of spousal support and bankruptcy law creates a complex but navigatable landscape. While bankruptcy cannot eliminate spousal support obligations, it can dramatically alter the financial dynamics between former spouses. For high net worth individuals, understanding their principles is essential for effective legal and financial planning. The law provides significant protections for spousal support recipients while preventing abuse of the bankruptcy system. But successful navigation requires careful attention to timing, characterization, and strategic planning. So what is the key takeaways from this today. Spousal support obligations are among the most protected debt in our legal system. They survive bankruptcy, they receive preferential treatment in asset distribution, and remain enforceable long after other debts have been discharged. This reality should inform every aspect of your divorce strategy and post-divorce financial planning. Well, that's it for this episode and Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley Firm is here to help. Be sure to subscribe so you don't miss any upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next time.